All right. Well, thank you everyone for joining the webinar today. Like I said just a few minutes ago, this is the fourth webinar of Con Maciel Carey's Labor and Employment webinar series. And today we're going to be talking about two topics that have garnered a lot of attention, both at the state and federal level over the past several years. There's been a lot of action as it relates to pay transparency laws, as well as non-compete agreements and the limitations that come with those two topics. So the way that we're going to handle the presentation today is we're going to review the pay transparency laws that have popped up throughout the country and provide some examples of a few of those state laws, some of the more recent ones, and cover some tips and things to consider when analyzing your pay structure and your job postings, and tips for compliance, and also things that you need to be on the lookout for when analyzing these issues. They are state specific and they do vary in some degree. And the same can be said for the non-compete agreements. We have several different state laws that have popped up over the past few years, limiting non-compete agreements to some extent in various different ways. And most recently, as of January 2023, we have the new proposal from the FTC to limit and ban non-compete agreements altogether, which would be a pretty sweeping rule coverage nationwide. So we're going to talk about that today as well. My name's Dan Deacon. I am a partner here at Con Maciel Carey in our Washington, D.C. office. I work in both the OSHA Workplace Safety Practice Group and the Labor and Employment Group. And in that role, I represent employers during state and federal OSHA inspections. And on the employment side, I basically handle an array of litigation, wage and hour issues, discrimination, and general HR compliance issues. I assist employees in reviewing and revising employee handbooks, workplace policies, and just your general day-to-day HR compliance advice. And I'm joined today by my colleague, Sam Rose, and I'll let him introduce himself.
Hey, everyone. My name's Sam Rose. I'm an associate with Con Maciel Carey out of the Los Angeles office. Like Dan, I also support both the labor and employment and the OSHA practice groups. So with OSHA, representing clients with anything from defending citations, getting involved from the investigation standpoint, and any step along the way with their appeal. And then from the labor and employment perspective, similar, a broad range of employment issues, wage and hour, and just some general litigation.
Great. So like I said at the beginning of the presentation here, we're going to go in order, covering the pay transparency laws first. Sam is going to take the lead on that and go over some of the different variations in the state laws that are out there, and cover a few specific states and local laws as they pertain to the pay transparency laws, and tips and compliance suggestions for you all to consider as you move forward in analyzing your pay structure. And like I said, your job postings, most importantly. And then we're going to follow it up with the overview of the non-compete agreement limitations and the various state laws that have come into play over the past few years covering that topic. We could, cover each and every state, but that would be an individual presentation in and of itself for each one of those states. So this is going to be a broad overview of things to consider as you review both of these topics and analyze your employment policies and practices. Of course, we're going to dive into a few specific states, but if you have any questions throughout the presentation, feel free to throw them in the chat feature on the webinar here, and we'll be sure to try and answer them on the go or towards the end of the presentation. We're going to leave some time open for Q&A. And if you have any questions following the presentation, feel free to reach out to me or Sam. We'd be happy to help and answer any questions that you may have. So these are very tricky issues that are relatively new, and changing very rapidly. And we thought this would be a good presentation this year because we have gotten a lot of questions over the past couple of years as it pertains to these new state laws that are popping up. So with that being said, I'll turn it over to Sam, and he's going to go over the pay transparency laws and kick us off with the first part of the presentation.
Thanks, Dan. So, starting with the pay transparency, you can go to the next slide, Dan. So generally, these pay transparency laws have been passed as sort of a broader wage and hour legislation. The statutes often have prohibitions against, asking for prior salary history and current salary history as a basis for an offer of employment. We're going to focus specifically on the portions of these statutes that require employers to publish wage ranges in job postings for their open positions, because those are the questions that we often get the most from employers. And the trend of these state legislatures passing these types of laws come from their concern that there's widespread pay inequity, discrimination, problems with employee morale, and streamlining the recruitment efficiency of the hiring process. So those are kind of the underpinning ideas of what these laws are intended to resolve. Next slide. So the pay transparency sections of these statutes tend to have very similar structures, although they have vastly different requirements depending upon the state that you're looking at. So they include generally which employers are covered by the law, and that's usually limited by the number of employees that the employer has based on the number of employees in the state, or for some states, it includes the number of employees in total. They include requirements on when the pay range must be disclosed for example, in the actual job posting, during the hiring interview process, or upon request by the applicant. So there's varying requirements based on that, depending upon the state that you're looking at. And it also varies depending upon whether you are talking about an external candidate that's applying to a job position or an internal candidate that you're looking to promote or transfer to a new position. And then they all tend to have some sort of remedy, which could include an investigation by the state agency, civil penalties being levied by the state, and some even include a private right of action by an aggrieved employee or applicant. So we'll start by looking at 4 of these laws and what they require and how they're different. Some of these are newer, some of them are older. So we have varying amounts of information based on how much the state has provided to date. So we'll start with New York State. SB S9427A, that's the law that will be going into effect September 17th, 2023. And it applies to employers with 4 or more employees. Right now, it's unclear whether the statute requires that all 4 of those employees be in New York State for the law to apply, or whether it just requires 1 employee in New York State and 4 employees generally. So the state hasn't issued any guidance or clarification on that yet. We expect certainly that at some point they will. And the law applies to jobs, promotions, or transfer opportunities that will physically be performed in part in New York State. And then it attempts to sort of lump in a bunch of remote job positions by also applying to jobs, promotions, or transfer opportunities that will be out of New York State, but which will report to a supervisor, an office, or other work site within New York State. So let's say, for example, you have an employee out in Texas that reports to a supervisor or reports to the employer's office within New York State. Any job posting for that position would be required to have the pay range as well. And the law requires essentially that the employer provide compensation or range of compensation in any job posting regarding an open position. And what it means by compensation or range of compensation is that the minimum and maximum annual salary of the hourly range that the employer, and this is from the statute, in good faith believes to be accurate at the time of posting. So if at the time you post the job, you have a good faith belief that that's what the salary range will be, later on it changes, you wouldn't necessarily be in violation of this law by the range changing later in time. In terms of penalties, the employers that violate this statute will be subject to a civil penalty of up to $3,000 per violation, and that there could also be some private rights of action and also some investigations by the state. Interestingly, the New York passed this law after New York City itself passed a similar law. The New York City law is already in effect and went into effect in November 1st, 2022. It actually was delayed for a couple months. I believe it passed back in March and it was supposed to take effect a month or two later, but there was delays in rolling it out. The New York City law applies to employers with 4 or more employees, at least one of which is based in New York City. And it has similar requirements in that the employers must provide pay ranges in job postings. The penalty for the New York City law is up to $250,000, which seems like a large penalty, but that's what they have deemed to be an appropriate penalty for violation of this law. So definitely employers in New York City should be aware of these laws because you're going to have potential investigations or penalties from both the state and the city by the end of the year. We'll move on to California. California's SB 1162 went into effect on January 1st, 2023. It applies to employers with 15 or more employees. And while the statute doesn't necessarily say where those employees need to be based in order for the employee to be covered, the labor commissioner issued an FAQ that essentially says it's the same as the COVID requirements, which means that one employee needs to be based in California for the law to apply. There actually was a lot of confusion about the California pay transparency law, and that's why the labor commissioner issued that FAQ shortly after the law went into effect, which attempted to clarify some of those ambiguities and questions, but we certainly expect that there will have to be more FAQs issued by the labor commissioner in the near future just to clarify some issues with the law. The California law similarly requires disclosure of the pay scale for a position in any job posting, which, similar to New York, requires the reasonable expectation of what the employer expects to pay. And it does not have to require bonuses, tips, or other benefits. That's one of the clarifications that the labor commissioner provided in its FAQ shortly after it went into effect. Employers in violation of the California law are subject to a penalty up to $10,000. However, there is a caveat in the law that allows for the first violation, no penalties would be assessed if the employer can show basically that they've updated all of their job postings with the pay scales to comply with the law. So it's kind of like a free pass on the first violation, essentially. So Maryland, they've had this law basically since 2020. So it was one of the older ones at this point. And it applies to all employers in Maryland, no matter how many employees they have. And it doesn't necessarily require employers to publish pay ranges like in the job posting like California and New York do. It actually only requires the employer to disclose to an applicant upon their request. So if you're in the process of interviewing a potential candidate for an open position in Maryland, and that candidate asks for the pay range for the position, the employer is required to provide that pay range. And so in that way, it's a little bit less burdensome than laws like in California and New York. But you still want to be aware that there are some obligations to applicants. And a violation of this section is subject to penalties up to $600 by the state. So the last example we have here is Washington. Washington's is also one of the newer ones. It went into effect January 1st of this year. So it's only been in effect for a couple months now. It applies to employers in Washington with 15 or more employees. Similar issues with New York and California in that it doesn't necessarily say whether all of those employees need to be within the state of Washington or whether it's just the number of employees that the employer has nationwide. It requires the employer to disclose the wage scale or salary range in in a posting for a job opening, just like California and New York. However, Washington also has seemingly an additional requirement that the job description include a description of all benefits and other compensation. So there's not an FAQ like the one in California yet, but you can kind of guess that would include bonuses, tips, and any other benefit that the employer provides for that position. Violations of this statute can result in penalties up to $1,000. So that's sort of the structure of the Washington law. So we put together some of these tips for compliance so that employers can ensure that they are not in violation of some of the requirements of these laws. The first is that while remote employees might be covered by the statutes, like for example, in the New York one, some of them are silent. And so that doesn't necessarily mean that they're not covered. It just means that the statute doesn't specifically require remote positions to be included. So it would be important for employers to at least consider whether they want to provide a pay range for a remote position in states that don't explicitly require it in their statutes. You'll also want to confirm compliance with local laws because a number of municipalities have enacted similar laws that go either above and beyond the state requirement, or the state doesn't have a requirement and these localities have. Some of those included are Cincinnati, Westchester County in New York, Ithaca, New York, Jersey City, New Jersey, and Toledo, Ohio. Those are just some examples. So if you know that your state doesn't require a wage range to be provided in a job description, you should just check with any localities that you operate in to ensure that there's not a requirement in those localities. It's also important for employers to audit their salary data for all their positions and set a set range that they expect to pay for those positions, especially so that if for whatever reason you're out of compliance with the law and there is an investigation by the state, you want to ensure that there's no potentially discriminatory application of the salary ranges. So just ensure that the salary ranges are either the same for all positions, or sometimes there's different ranges depending upon the location of the job, but you don't want to have it for a discriminatory purpose. You also want to make sure that your internal HR policies related to pay transparency and job postings are updated. So whoever is responsible for updating your job postings knows that which states have these types of laws. And so you want to make sure that they understand the law and how it's applied to your job postings. You'll also want to consider using external data to set up and support your compensation models so that it's sort of an independent way of setting these pay ranges. And that's also hand in hand with making sure that these ranges are not discriminatory. And lastly, you'll want to ensure that any third-party posters are aware of their requirements. So if you post a job on Indeed, or if you use a recruiter to recruit potential applicants for an open position, many of these laws apply to third-party postings and third-party recruiters. So if you hire a recruiter and the recruiter doesn't provide the pay range to an employee, you could be found to be in violation of the law in the states that have these laws. So you'll just want to make sure that any third-party person who you work with is also aware of all these laws. So that's kind of the rundown of these pay transparency laws. Like Dan said at the beginning, if anybody has any questions, you can put them in the chat, or you can reach out to us after the webinar is over, and I'll turn it over to Dan to talk about non-competes.
Excellent. Thanks, Sam. And yeah, that was a great overview of the variety of different examples and the types of issues that may arise under those pay transparency laws. And really, these are just things that you need to look into specifically, especially as we mentioned on that last slide there. If you are posting for jobs that can be remote anywhere across the country, that does raise some serious implications about application of state or local pay transparency laws. So it would be good if you are employing and posting for jobs for remote workers in various jurisdictions, whether that's nationwide or in certain geographical locations, that you do your research and you check those state and local laws before developing and creating those job postings, and making sure that you're dotting your I's, crossing your T's as it relates to all these laws, because depending on the jurisdiction, as Sam noted, there are some pretty steep penalties in certain cases, and potentially private rights of actions, which do have some damages associated with that, including attorney's fees. So definitely good to do your research on those issues and make sure that you're in compliance nationwide. So now we're going to turn the page and talk about non-compete agreements. And this is another topic that has garnered a lot of attention over the past several years, mostly on the state level, but most recently on the federal level as well. Like I said at the beginning, we have the new proposed FTC rule, which would essentially be a pretty sweeping ban of non-compete agreements throughout the country, applicable nationwide. So we're going to talk about that in a few slides here. But I think it would be helpful to kind of start from the beginning and go over what is a non-compete agreement, right? So what that is it's a restrictive covenant, right? And it's typically executed as part of an original employment agreement at the time employment is accepted. And what it does, and perhaps you all know this already, but it's worth for those that are new to these topics to go over it, right? It prohibits an employee from working for a competitor for a specific period of time after separation. And the flip side of that, or the corollary piece to the non-compete agreements, or the non-solicitation agreements, it's the same type of restrictive covenant prohibiting employees from soliciting customers from you as an employer, right? And if we look at just some of the data, there was a study done by the Journal of Law and Economics in 2021 that found approximately 18% of Americans are bound by a non-compete agreement. So that is a pretty staggering number, and it just goes to show how many employees and likewise how many employers are using this tool as part of their employment practices. And perhaps many of you on this webinar are as well, and that's why you're here, right? So when we're thinking about non-compete agreements, right, you want to take a look at three things for it to be effective and enforceable for the most part. And this is just the general overview of how non-competes work. And we're going to dive into those state-specific limitations here in a few slides. But generally, in order to be considered valid, the non-compete needs to be satisfying three different elements. One, it needs to be supported by consideration at the time it is signed. So a lot of employers, we get questions, well, what is consideration, right? So an offer of an employment is generally considered adequate consideration, but we typically suggest that you link it to identify a specific portion of an employee's compensation or other benefits to remove any questions about the adequacy of consideration, right? And this is standard contracts 101 law, right? A contract needs to be supported by adequate consideration. There needs to be an offer. It needs to be accepted. In addition to that, right, we need adequate consideration. We also need the reason that this non-compete is being offered. It has to be to protect a legitimate interest of the employer. And we're going to talk a little bit about what those legitimate interests are on the next slide here. And the final piece is it needs to be reasonable in scope, geography, and time. So we'll go over that as well. Keep in mind that the legitimate interests of the employer, the scope and geography, the reasonable scope, geography, and time elements, those have generally been bore out in case law, and it may vary by jurisdiction. So again, this is another area of the law that is very state specific, and it varies throughout the country. But we're going to go over some kind of key elements that have been bore out in those case laws as to what these legitimate interests are and what is considered reasonable in scope, geography, and time. One other piece to just go back to the consideration part, if you have an existing employee that is not subject to a restrictive covenant or a non-compete agreement, and you do want to enter into a non-compete agreement with that existing employee, most courts, or I should say most states, require some additional consideration to be bore out in order to make that non-compete valid, right? So whether that be a promotion, additional salary, a bonus, in some states, continued employment, regardless of the length of time, that may be considered adequate employment or adequate consideration for the non-compete, but not usually. It really needs to be something additional, something of value to make that non-compete with an existing employee valid. Okay. So on this slide, we're just going to talk about the validity and enforcement of these agreements and how they do vary by state law. And this is just a couple examples of where either this is bore out in the state legislature, the law that is passed, or by the courts itself, right? So there's a few examples that you see on the screen here of some states that don't permit non-compete agreements at all, those being California, Oklahoma, and North Dakota. Now, in those states, a non-compete agreement can be enforceable in the sale of the goodwill of a business. So there are some very narrow, limited exceptions, right? It can also be enforceable in the dissolution of a partnership. In other words, partners can't agree, or they can agree not to carry on a similar business. Again, we have to go back to the other pieces as well, the consideration, and also the reasonableness in geographic scope and time to make sure that these are valid. But generally, in those three states that you see here, a non-compete agreement is generally prohibited, except in those very narrow circumstances. Now, most courts throughout the country disfavor non-compete agreements in some form or another, right? There's been tons of case law, and this is litigated constantly at the state level, but they are not prohibited, right? We just went over that 18% of Americans are subject to a non-compete. Many of those can be what we consider perhaps low-wage workers too. But the idea here, and the reasons that courts disfavor these types of agreements, is they consider it a restraint on trade that interferes with competition and impairs the availability of services and the ability of workers to follow their personal interests. So if you have a non-compete agreement that gets challenged in court, it will be scrutinized very closely. Of course, those three elements that we just talked about on the screen, the prior slide, are going to be the ones that courts are analyzing on a very, very close level and with a fine eye. So it's important when you're drafting these non-compete agreements that you take your time, you make sure that it is reasonable, that you have adequate consideration, and that it's narrowly tailored to protecting that legitimate business interest. So what are those legitimate business interests? So regardless of how well you draft your non-compete agreement, no court is going to enforce it unless you as the employer can identify that legitimate business interest that you are seeking to protect. So again, it's really important that you think about these before you just throw out non-compete agreements to employees. What exactly are you seeking to protect? Case law has expanded on what that legitimate business interest can mean, but again, it varies by jurisdiction. Courts have been a little reticent to define exactly with clear terms what a legitimate business interest is, but they have been clear on a few things, right? It is not to merely protect the employer from general competition. So if your business interest is, well, I just want to protect my business from general competition around me, that is not going to be sufficient legitimate business interest in the court's eyes generally. Employers don't have an interest in preventing employees from competing through the use of general knowledge, skill, or facility acquired by the employee through training or experience. So if it's your intent just to protect a very skilled employee from leaving, now that does get very nuanced when it comes to specific trades and jobs. But if it's a general employee and that's your general business interest is just to protect your employees from leaving, that is not going to be considered a legitimate business interest. In doing this analysis, it's a totality of the circumstances review. So that goes back to there's no one size fits all answer, right? The court is going to analyze this based on various different factors, and it differs by the jurisdiction that you're in. And they're going to analyze whether that business interest that you have proposed is legitimate and worth protecting, right? So here we have a couple examples of what courts have identified as potential legitimate business interests. Again, this isn't a slam dunk each time that you identify these. Again, the court's reviewing this as a totality of the circumstances review. So you want to have some evidence and really a well thought out reason of why you have this non-compete agreement and what that legitimate business interest is. So a few of the things that we see that have been upheld are things like trade secrets, things that you don't want getting out to your competitors, right? Your customer lists, goodwill with customers, your business practices, your sales practices, perhaps, intellectual property, your profit margins and costs, and things like confidential information, your proprietary and confidential information that increases your business in value because it is not known by a competitor. And also things like training and education. So these are just a few examples of the types of legitimate business interests that have found to be valid and support the non-compete agreement. But again, you want to have a well thought out reason of what those trade secrets are, what that intellectual property is, and make sure that it is something that you have thought about and it's worth protecting, right? All right, that final element that we're going to go through is that the non-compete needs to be reasonable in scope, geography, and time. So when a court reviews this, they're ultimately going to answer whether the provisions of the non-compete agreement are overbroad, right? The inquiry is based on the totality of the circumstances again, and really what it needs to be is limited with respect to time and scope in a manner that's not broader than necessary to defend or protect that legitimate business interest. So this is another area that is varies by jurisdiction, but it can't be a non-compete agreement that prohibits and restricts an employee from practicing their trade for an unlimited amount of time, right? So some courts have found 1 to 2 years to be presumptively reasonable in many jurisdictions, potentially 5 years if we're talking about the entire sale of a business. When we're talking about geography, right, this is one that is very, very specific, and you can't really define parameters around it, right? We're talking about, is it feasible? Is it feasible and reasonable for this employee to not practice their trade in this geographical location? So if we have an employee that's being restricted from practicing in an entire state, depending on the circumstances, it may be permissible, but probably unlikely, right? It usually is pretty narrow in terms of the geographical scope and what is deemed reasonable. But that question that the court is going to be answering is it feasible? Is it feasible for this worker to gain employment in their profession in this certain area? And then finally, the scope, and this ties back to the legitimate business interest, is it unreasonably necessary to protect the employer's legitimate business interest? So this is really kind of the overarching question of, do you really need this non-compete agreement to do what you propose it to do, right? Is what you're trying to protect a legitimate business interest, and is the time and geography limitations there, are they reasonable and link up with what that legitimate business interest is? So it all comes down to a little bit of discretion in the court's eyes. But again, these are the concepts that you need to be aware of and the things that you need to be thinking about when drafting those non-compete agreements. So there are certain exemptions. Again, these have also been borne out in case law and in some cases state legislation. But there are some professions that may be exempt from non-compete laws, again, depending on the jurisdiction. So some of those exempt industries or professions are things like lawyers, doctors, nurses, psychologists, social workers, veterinarians, and broadcasters. And the reason behind that is for public health and public policy reasons, and ensuring the free flow of information and ideas to motivate the prohibition or limitation of non-compete agreements for those specific occupations. So if you're in those industries, it is certainly something that you want to look very carefully at in your jurisdiction as to whether a non-compete agreement is enforceable. If you have, a law firm or a medical practice, these are things where non-compete agreements may be not enforceable in some circumstances, but typically they would be. All right, so now we're going to jump into some of the legal updates. And this is where we're going to go over some of the various state trends as far as the laws that have been passed over the past several years from a statutory perspective. So just in 2022, there were 5 states in the District of Columbia that affected legislation that was designed to limit the use of non-compete agreements in some form or fashion. And we have an additional 18 states that have proposed or have pending legislation addressing this very topic. So when we look at what exists already in state statutes, they vary significantly, and we're just going to go over kind of some of the key ones here. So we already talked about California, North Dakota, and Oklahoma. They basically ban non-compete agreements outright with a few narrow exceptions. Colorado, Illinois, Maine, Maryland, New Hampshire, Oregon, Rhode Island, Virginia, Washington, and Washington, D.C. They prohibit non-compete agreements unless the employee earns above a certain salary threshold. And there's certain nuances, of course, in all those state laws, but that's kind of the key threshold there is, do they earn above a certain salary? And then some other states like Iowa and Kentucky limit the use of non-compete agreements just for certain professions like healthcare workers. When we look at the trend of what are these laws and how are state legislatures thinking about them. So the 5 bullets that you see on the screen here are kind of the key elements that we're seeing in all these state laws. They're limiting the use of non-competes to protect trade secrets, right? That's the kind of the big overarching legitimate business interest that state legislatures have recognized and explicitly sought to protect. The other is setting minimum salary threshold values. So if an employee is earning above, or I should say below, a certain salary, a non-compete agreement would be banned outright. Term limits on post-employment restrictions. So that gets into the geographic scope and time piece. There's some states that are silent on that altogether. Some have set specific term limits in which you can't go beyond. And then there's some employee notice and time to consider requirements. So we're going to go over some of these, just a couple state laws in a few minutes here. But there's some states that say you need to give employees 14 days to consider the non-compete agreement before signing it, right? You can't just throw it on the desk during the hiring stage and say, here, please sign this agreement, and it's effective, right? It doesn't work like that in many states. You need to give them time to consider it and perhaps time to consult with someone to get a legal opinion on that. And then finally, the last piece that we're seeing in some of these state laws is the limitations on legal recourse against employees for violating those. So the big topic that a lot of people probably want to talk about, and that is really at the forefront of everyone's mind, is this new FTC proposed rule. It came out just at the beginning of this year on January 5th, 2023. But it really stems back to a July 2021 executive order directing federal agencies to implement actions intended to increase competition, which included a directive to the FTC to exercise its rulemaking authority to curtail the unfair use of non-compete clauses and other clauses or agreements that may unfairly limit worker mobility. So this rule that was proposed just at the beginning of this year, it declares non-competes to be an unfair method of competition for an employer to enter into or attempt to enter into a non-compete clause with a worker, maintain with a worker a non-compete clause, or represent to a worker that the worker is subject to a non-compete clause where the employer has no good faith basis to believe that it is enforceable, right? So what that means is basically it is a sweeping, broad ban on non-compete agreements. It would also require employers to rescind existing non-compete clauses and to provide individual written notice to all current and former workers bound by any of those non-compete agreements, stating that the clause is no longer in effect and may not be enforced against the individual. So this rule is being considered. They had a 60-day comment period. We actually submitted comments on behalf of an employer coalition. There is quite a few different topics, I should say, as well, that are up for debate, right? So the FTC rule that is proposed is not final. They did ask for comments on some proposed alternatives as well. So instead of, for example, the categorical ban on all non-competes, there's a proposal, or I shouldn't say a proposal, but a consideration of a rule that would presumptively make non-competes unlawful, but employers could rebut that presumption with clear and convincing evidence that a non-compete clause is unlikely to harm competition in the labor markets or identify some competitive benefit that plausibly outweighs the harm. The other alternative that they sought comment on was instead of a uniform ban, the rule could prohibit non-competes only for subsets of workers defined by job function, occupations, or earnings, or some combination of those. So more akin to what we're seeing in the state laws, for example, or I should say a good subset of state laws. And then the final one that they sought comment on was a blend of those two approaches, such as a prohibition on non-competes for certain categories of workers and a rebuttable presumption of unlawfulness for others. So this is something that we're watching carefully, and it could have a broad sweeping effect throughout the country on a good chunk of employers and employees. Like I said at the beginning, nearly 18% of American workers are subject to a non-compete, and that could disappear overnight to some extent, right? And the genesis behind this rule is the FTC is estimating that the proposal could increase wages by nearly $300 billion per year and expand career opportunities for about 30 million Americans. And it's really based on that preliminary finding back in 2021 that non-competes constitute an unfair method of competition. And the FTC's belief is that it's a violation of Section 5 of the Federal Trade Commission Act. So that's the overview of this FTC proposed rule, something that is not final yet. And there's a couple different variations that they are considering, but something to keep a close eye on as we move forward through 2023. One of the more recent non-compete laws that was passed on the state level was in Washington, D.C., my hometown now, right? So D.C. was actually originally set to have one of the broadest non-compete bans in the country under its original proposal. That was proposed by the DC City Council back in January of 2021. It sparked major backlash from the DC business community, and the DC City Council ultimately delayed the act's enforcement date to April 2022 to further study the impact on employers and have discussion with the regulated community. So what ended up happening was the DC City Council amended the act. The original proposal was basically an outright ban on all non-compete agreements, but the DC City Council ultimately amended it. And what it did was set a threshold value, essentially, for when non-competes can be considered valid. So the good news for employers in DC is that amended law scaled back the most onerous provision, an outright ban, right? And now it only applies to covered employees, which are those who earn less than $150,000 per year. And there's a couple of additional elements in there that you see on the screen. Those who spend more than 50% of their work time for the employer working in the district, or whose employment is based in the district, and the employee regularly spends a substantial amount of their work time for the employer in DC, and not more than 50% of their work time in another jurisdiction. So that is a mouthful, but basically if someone spends more than 50% of their time working for an employer in DC, they would, and earns less than $150,000 a year, they cannot be subject to a non-compete agreement. Some other key provisions that we see in some other state laws as well. Employers need to provide the non-compete agreement to highly compensated employees in writing at least 14 days prior to the start of employment or execution of that agreement. So again, that's one of those required notice provisions that gives employees time to think about it. You can't just throw it on the desk during the hiring process and ask them to sign it. There's got to be a 2-week consideration period for that employee, that highly compensated employee, I should say. Some other things that were specifically outlined in this law: confidentiality agreements remain permissible, and the law also scaled back the restrictions on what are known as anti-moonlighting agreements. So under certain circumstances, you can enter agreements with employees that prohibit them from simultaneously working for other companies while they still work for you, right? Okay. So the final one that we're going to go over here is Illinois. And I know that there was a couple other updates in Oregon, Nevada, but we're going to focus here on DC and Illinois because these have largely the most recent and kind of the trend in what a lot of these states are passing. So the Illinois law went into effect on January 1, 2022. It's the Illinois Freedom to Work Act that was amended to provide some additional limitations on non-compete and non-solicitation agreements. And this law also sets a threshold value, right? So we're looking at how much is an employee making as that first initial consideration. Non-compete agreements are banned for employees earning less than $75,000 annually. That salary threshold, and that's current right now, $75,000 annually, but it is set to increase incrementally over time. The next one being January 2027, it will go up to $80,000. January 2032 goes up to $85,000, and January 2037 it goes up to $90,000. There's also specific language pertaining to non-solicitation agreements in this law. Those are similarly banned for employees earning less than $45,000 annually at the moment. That's also set to increase incrementally over time in the same manner as the provisions for non-competes. The one nuance here with the Illinois law is that these non-competes and non-solicitation agreements can't be enforced when an employee is furloughed or laid off due to COVID-19 or some other similar circumstances, unless the employee receives some type of compensation to bridge the gap between the base salary at the time of that layoff and the salary earned through subsequent employment. They also have the same, it's not on the screen here, but the same procedural notice requirement that we saw in DC. You need to give 14 days for that employee to review the agreement before signing it. So now we're going to get into the last final steps about some tips about when you're hiring employees with restrictive covenants and some steps for you all to consider to protect your business. Excuse me. So the key thing that you want to do, right, and the reason that you're creating and issuing these non-compete agreements is to protect your business and protected from interfering with competitors' restrictive covenants, right? We have to take into consideration new employees coming to you with a non-compete agreement. So what do you do in that hiring stage? So when you're considering a new hire, one of the things that you want to ask during that interview is whether they are subject to any employment agreement. And you're going to want to get your hands on that and take a close look at it. And it's probably a good idea to have someone, the head of HR or your legal counsel, take a close look at that to make sure that A, it's valid, and B, that you as a company won't be violating any of the provisions outlined in there, right? It would be the employee violating their non-compete agreement, but it can cause legal issues for you as an employer as well. So inform the applicant that the company insists on full compliance with that employment agreement. And you need to make sure that the applicant doesn't disclose or use any of the competitor's confidential or proprietary information. So really set the boundaries, make sure that your expectations and requirements are very clear and that you fully intend to comply with the former employer's agreement and whatever those provisions might be. So at the post-hiring stage, there's, it doesn't just end there. When you hire someone, you want to make sure that not only the employee that you hired, but any management folks that are overseeing that employee understand exactly how to comply with that restrictive covenant. So you should have those new employees create a comprehensive customer list that the employee serviced at their former employer or about whom they have confidential information, and make sure that you create a wall, essentially, right? And update that list regularly. So you don't want to get in the business or find yourself being alleged of flipping, right? Or you're the one that's hiring an employee and soliciting an employee for customer lists, confidential information. And we see this all the time. It creates lengthy litigation. So you want to do your homework upfront and at the beginning and make sure that you're creating that ethical wall, so to speak, between the business that the employee serviced at their former employer and what they're doing for you. So what do you do if one of your employees leaves for a competitor, right? And this is getting back to the whole reason that you have these, right? You want to protect your business. So the first thing that you should do is conduct a comprehensive exit interview where you're going to remind the employee about that non-compete agreement and that non-solicitation agreement, any restrictive covenants that he or she may have entered at the beginning or at some point in the duration of their employment. As with any termination, you're going to collect all company issued property, things like cell phones, computers, any documents, key cards, certainly customer lists, anything like that should be secured and walled off from that former employee, making sure that you remove their access to the computer networks, any emails and servers so they can't access any information, and secure any of those hard drives or laptops that the employee may have had. So you're going to want to conduct an inventory of those and make sure that you have all of the confidential proprietary information and trade secrets that employee had access to. Make sure that he or she doesn't have access to them anymore and that they're protected. And then you should also, finally, this is one of the more important pieces, contact that new employer and notify them of the employee's obligations under his or her employment agreement. That way you're setting the stage and everyone's on the same page as that employee begins new employment after termination. And then finally here, we're going to secure our market position. And this is really what you want to do, right? Is make sure that you're not harming the business. You need to fight for your customers and your business. So identify any new employees or executives that are going to be handling those accounts or servicing other customers. Do so publicly. And you really want to assess those business relationships that are most vulnerable. Make sure that you're making in-person contact as soon as possible and really honing in on building that relationship and maintaining it so you don't potentially lose any business. And then you want to send correspondence to customers announcing whoever that new rep may be, right? If you don't have that in-person contact for, a vulnerable customer or someone that you may lose anyway, if it's not feasible, make sure that you have some type of public announcement or correspondence to those customers who will be with a new rep or a new employee, client service manager, whoever that may be. Make sure you make that relationship from the start. And then really remind those customers, those clients, why you do business or why they do business with you, not why they should not do business with the ex-employee. So don't focus on the employee that left, focus on your capabilities, your service, and what you bring to the table. And most importantly, don't defame a former employee. You don't want to get into legal trouble on defamation issues. It's really building those relationships, maintaining them, and highlighting the services that you provide. It's not the person, it's the business. And then the last piece is communicating with your current employees. Tell any remaining employees about fair communications and competition. Make sure that you're prohibiting the discussion of the circumstances of that employee's departure, and not accusing ex-employees to customers or business partners of leaving for nefarious reasons, or accusing them of taking trade secrets or anything like that. Continue on with business and communicate with current employees about any unusual activity by the ex-employee's departure, and certainly keep an eye out for any instances in which there may have been or is currently solicitation of customers or stealing of trade secrets or proprietary information. So with that being said, we are done with the presentation today. We'll leave it open for the next couple minutes here, and feel free, if you have any questions, to issue those in the chat function, or feel free, like I said, to email me or Sam with any additional questions. We have our webinar series up on the screen here. The next one is going to be Thursday, May 11th, which is going to cover managing internal investigations. And then we'll have 6 more up throughout the end of the year here after that. So we do these once a month on labor and employment topics. We also have an OSHA webinar series that we do once a month as well on workplace safety and health topics. So feel free to tune into any of these throughout the course of the year. And we also have our blogs that provide a lot of information where we're posting about these topics and some of the ones that we've talked about today. Here is our contact information if you have any follow-up questions following the presentation, or you need help with any labor and employment or OSHA issues at any time. So with that, if anyone has any questions, again, feel free to type them in the chat or email us at any time.
Looks like we have a few questions in the chat that we can try and answer real quick at the end here. The California trade pay transparency law, it's actually already in effect and went effect on January 1st of this year. There's a question about whether there's an exception in the New York State law about collective bargaining agreements, and whether a negotiated pay must be disclosed. There's not a specific exception in the law, just in like a brief overview of it. It does say compensation or compensation range. So if there is no range, probably the best practice would be to just disclose the actual negotiated compensation. And then there was a question about traveling employees to do work out of state. A lot of these, I don't know specifically about the California and New York ones, but I can say generally the laws apply when the job can or is performed within the state. So it's possible that if you have employees who travel to another state to perform the job, that it would include those positions, but that's a pretty nuanced issue that might need additional research. But just generally, that's what the law requires.
Yep. And I see one question here about how aggressive is the state of Washington about imposing penalties for non-competes that violate the statute. So this is regulated and investigated by Washington DLI, who is notorious for some pretty strict enforcement. But the statutory penalty is relatively low. I guess you could say it's $5,000 against the employer, or actual damages if it is greater. So the statutory I guess, penalty is $5,000, but it can be much more than that depending on what those actual damages are. And you can be ordered to pay things like attorney's fees, expenses, and costs as well. All right, well, I think that covers everything from the chat. So again, if you have any follow-up information or questions, feel free to reach out to us after. And again, thanks for joining us today, and we really appreciate you tuning in. It's always enjoyable getting on and talking about these new employment issues. So yeah, thank you very much, and looking forward to seeing you again soon.
Thanks, everyone.